Legal and regulatory considerations in arbitrage trading is often considered a low-risk strategy, but it's important to remember that it operates within a complex framework of legal and regulatory requirements. 1. Securities laws and market manipulation. Securities laws form the backbone of financial market regulation, and arbitrage traders must operate within these rules. These laws ensure market integrity by preventing activities like market manipulation and insider trading. Market manipulation is a broad term that encompasses various illegal activities, including spoofing, layering, and wash trading. Spoofing, for example, involves placing large orders to artificially inflate demand or supply and then canceling the orders before they're executed. Similarly, layering involves placing multiple fake orders to create the appearance of market activity, misleading other traders. These practices distort the true value of assets and are illegal in almost every market. Regulators, including the SEC in the US and ESMA in Europe, closely monitor for such activities. Violating securities laws can lead to severe penalties, including fines, sanctions, and even imprisonment. Traders must ensure their strategies are transparent and do not engage in manipulative behaviors, even unintentionally. Another key component of securities laws is the requirement for market transparency. Traders must provide accurate and timely information about their trades, ensuring that market prices reflect genuine demand and supply. Market manipulation is illegal. Avoid spoofing, layering, and wash trading too. Insider trading and disclosure requirements. Insider trading occurs when someone trades based on material, non-public information. This is one of the most serious offenses in financial markets and can result in significant legal penalties. For arbitrage traders, the lines can sometimes blur, especially when trading in markets where information flows rapidly. For instance, let's say you learn about a merger between two companies before the news becomes public. Acting on this information, even if it comes through informal channels, is considered insider trading. The same applies to rumors or leaks from corporate insiders. Regulatory bodies such as the SEC have been increasingly vigilant about pursuing insider trading cases. To mitigate the risk of insider trading, traders must ensure they only use publicly available information when making trading decisions. It's critical to verify the sources of information and avoid acting on any private knowledge that hasn't been disclosed to the market. In addition to insider trading laws, many markets have disclosure requirements for large traders. For example, in the US, if you hold more than 5% of a company's stock, you are required to disclose your position to regulators. This is designed to promote transparency and prevent market manipulation by large players. Adhering to these disclosure requirements is crucial, as failing to do so can lead to hefty fines and legal consequences. Transparency is a cornerstone of legal and ethical arbitrage trading. Regulatory differences. Cross jurisdictions. A major challenge for arbitrage traders is navigating the regulatory differences across multiple jurisdictions. Trading internationally means dealing with varying laws and rules, and what might be perfectly legal in one country could be illegal in another. For example, some countries impose capital controls, which limit the flow of currency across borders. In contrast, other countries have much more liberal policies, allowing for greater flexibility in cross-border arbitrage. In addition, certain markets, such as derivatives, may be heavily regulated in some regions and not in others. Regulatory agencies like the CFTC in the US, the FCA in the UK, and the European Securities and Markets Authority, ESMA, each enforce their own rules for market participants. These can include restrictions on leverage, trading hours, settlement times, and reporting requirements. One major area where regulations differ is in taxation. Cross-border traders often face varying tax regimes, including capital gains taxes, transaction taxes, and withholding taxes. Some countries impose additional taxes on short-term trades, making it essential to consider how taxes might affect the profitability of arbitrage opportunities. Fourth, algorithmic trading rules and compliance. The rise of algorithmic trading has introduced new regulatory requirements for arbitrage traders, especially those using high-frequency trading (HFT) strategies. Regulators have increasingly scrutinized these automated systems, particularly in cases where algorithms may inadvertently disrupt markets. For example, in Europe, MiFID II, Markets and Financial Instruments Directive, introduced strict requirements for algorithmic trading. Traders must disclose how their algorithms operate and ensure that they comply with transparency rules. MiFID II also requires traders to test their algorithms under various market conditions to ensure they don't contribute to market instability. In the US, the SEC and FINRA have introduced similar rules aimed at increasing the transparency of algorithmic trading. Traders using algorithms must maintain audit trails, which means keeping a detailed record of each trade, including the time it was executed and the algorithm's decision-making process. 5. Ethical standards and market conduct. While legal regulations are important, ethical standards are just as critical in arbitrage trading. Ethical behavior ensures the integrity of the market and promotes fairness for all participants. Conflicts of interest can arise in many ways, especially if you are managing both your own and a client's account. For example, using information from one account to benefit another is unethical and can result in legal penalties. Many countries require traders to disclose any potential conflicts of interest to ensure transparency. In addition, traders must adhere to rules around market conduct, which include avoiding behaviors like front-running, insider trading, and falsifying market conditions. Ethical standards vary slightly between jurisdictions, but the underlying principles of fairness, transparency, and integrity are universally upheld. 6th, cross-border arbitrage, taxation and compliance. Cross-border arbitrage opportunities can be highly profitable, but they come with a unique set of legal challenges, particularly when it comes to taxation and compliance. Different countries impose varying tax rates on capital gains, dividends, and interest, making it essential to understand the tax implications of each trade. Some countries also have withholding taxes, which apply to interest or dividend payments made across borders. Traders need to account for these taxes to avoid eroding their profits. In some cases, traders may be able to take advantage of tax treaties between countries, which reduce the tax burden on cross-border transactions. For example, many countries have treaties that prevent double taxation, ensuring that traders aren't taxed twice on the same income. Transfer pricing rules are also a concern for traders engaged in cross-border arbitrage. These rules dictate how transactions between related parties in different countries should be priced to ensure they reflect market conditions and don't artificially shift profits to low-tax jurisdictions. 7. Compliance programs and risk management. Implementing a comprehensive compliance program is one of the most effective ways to manage legal and regulatory risks in arbitrage trading. A good compliance program includes policies and procedures designed to ensure all trading activities comply with local laws, monitor for potential violations, and mitigate risks. One key element of a compliance program is risk assessment. Traders must regularly assess the risks they face in different markets, including changes in regulation, technology, and market conditions. This proactive approach ensures that traders are prepared to respond to evolving risks. Working with legal counsel is also crucial. Compliance officers and legal experts can help traders stay up to date with new regulations and ensure that they meet all reporting and disclosure requirements. Additionally, many traders use compliance software to automate certain aspects of their compliance programs. These tools can help track trades, monitor risk exposure, and generate reports required by regulators. 8. Emerging trends in regulation. The legal landscape for arbitrage trading is constantly evolving. New technologies like blockchain and cryptocurrency trading have introduced significant challenges for regulators. While blockchain offers transparency, its decentralized nature makes it difficult for regulators to enforce traditional laws. Cryptocurrency markets in particular are subject to different rules depending on the country. Some countries have embraced digital currencies, while others have banned or restricted them. Traders must stay informed about the regulatory developments surrounding cryptocurrencies to avoid potential legal issues. In addition, artificial intelligence, AI, and machine learning are playing a larger role in trading. These technologies raise questions about how algorithms should be regulated, especially as AI-driven strategies become more autonomous. Regulators are developing new rules to ensure that these systems don't undermine market stability. Staying ahead of these emerging trends is essential for traders who want to remain compliant and capitalize on new opportunities. Emerging trends. Blockchain, AI, increased regulation. Arbitrage can be highly profitable, but only when done within the bounds of the law. By understanding and complying with legal and regulatory frameworks, traders can protect their businesses and avoid costly penalties.